Will that incident have any effect upon the normal master and servant relationship and the actual position of domination? When the matter went to court, the court said, undue influence is a cover. As long as a person is in the cover like under an umbrella, who is controlling the master? The master is the umbrella. He is protected by law. But once he goes out and then contacts an advocate, he has independent advice. That means he is no longer under the control or domination of the master. He is under the control or domination or influence of somebody else. Because of the influence of the advocate on him, he entered into the transaction. Not because of the influence of the master over him. Therefore, even though the master is in a position to dominate, he has actually not dominated. Hence they said there is no undue influence. So remember friends, if independent advice is sought after the influence and before the transaction, after the influence and before the transaction, then you cannot say there is undue influence. We have no option but to say he entered into transaction because of the influence of the advocate, not because of the influence of the master. Hence there is no undue influence. So don't jump to conclusion because the relation between the two parties is such that one is in a position to dominate the other, automatically the other is definitely. You have to further see whether really it affected the transaction. If there is an independent third party intervention which is responsible for this person giving the consent, then the consent is said to be not law. It is absolutely freely and voluntarily given consent. This is the second one. Let's go to the third and fourth. I deal with the third and fourth, that is fraudulent misrepresentation and misrepresentation together. 17 and 18 sections of Indian contract. Friends, when two persons enter into an agreement, in the process of entering into an agreement, they will be negotiating. A lot of dialogue takes place between them. I am sure if I want to purchase a scooter, I don't purchase blindly. I ask some question. Is it your scooter? When did you purchase? How many kilometers you traveled? How many accidents it met? What is the how many kilometers is given per liter? Is it maintained by you or is it a community vehicle? Just questions I will ask. And other person who wants to sell the scooter or the bike will also be definitely giving some answers. This is called the negotiation process. Even for a small item like a bike, we indulge in so much negotiation. When contracts worth crores and crores are being entered, there will be a lot of negotiation. And in the process of negotiations, when I am telling information to you, knowing full well that you will take a decision basing upon the information I give you. I repeat, I am giving you information. Basing on the information I am giving to you, you will be taking a decision whether to enter into a contract with the other. Right? Should my information or the information I am giving to you be truthful or can it be false? Naturally, because you are taking a decision to enter into a contract basing upon the information I give you, but it goes without saying, no necessity of any law, that the information which I give you must be true. Suppose it is false. I am always giving information to you by making statements. Statement to influence your decision making process, therefore it is called representation. Should the representation be true or should the representation be false? This is truthful only. If it is not, untrue information is true. And friends, it amounts to this representation. Untrue information or false statement may be made by me with two different kinds of mercy. One, knowingly, intentionally, deliberately. The other one, not caring to know whether what I am telling is true or not. If I make a statement which is false, not caring to know whether what I am telling is true or false, you ask something, I casually tell something, I never have intention to cheat you, then it is called misrepresentation. But if I tell the information to you knowing pretty well that whatever information I am telling you is false, deliberately, intentionally, I give you wrong information so that you will be influenced to enter into a contract with me, then it is called fraudulent misrepresentation. In other words, misrepresentation, which is giving false information, can be of two types: intentional misrepresentation, innocent misrepresentation. Innocent misrepresentation is simply called misrepresentation. Intentional misrepresentation is called fraud. Fraud is covered in section 17 and misrepresentation is covered in section 18. Some of you were present when I think last time about misrepresentation. I normally tell one joke. Can you recall? I said when I am evaluating the papers of an LLB student, he defined misrepresentation according to section 18 in one way. Do you recall? Recently, I think you were there in the class of note 23. Can you recall? Huh? Misrepresentation is a representation made by a miss. That's what he wrote in the examination. New paper. When evaluating, misrepresentation is defined in section 18 of Indian Contract Act. According to section 18 of Indian Contract Act, misrepresentation is a representation made by a miss. Probably he must have had a nice experience. Unable to get over that experience and he is putting his own experience on the paper. But that is not misrepresentation. It is not MISS. It is only MIS. That is simply giving wrong information. See, suppose I ask Mr. Razu, he is trying to sell his bike to me. Is it your bike? Yes. When did you purchase? 4 or 5 years back. How many kilometers it traveled? 10,000. How many kilometers it gives per liter? 22. I asked something, he told something. Has it met with an accident? Never. Okay. Actually, it met with 15 accidents. And it gulps petrol, it gives only 5 kilometers per liter. It traveled already 1,10,000. 1 lakh is erased and 10,000 is retained. Well, has he told me that information deliberately or recklessly, carelessly, not bothering to find out whether what he is telling is true or false? If he doesn't bother to find out and just like a heck of the moment he tells whatever comes to his mind, we call it as a misrepresentation. Remember, he may be innocent, but ultimately he gave wrong information. It is that wrong information that influenced me to enter into the contract. Why should I suffer if he gives wrong information to me? He may not have the intention to cheat me, intention to defraud me, may not be there. But then, fact remains, he gave wrong information. Whenever untruthful information is given to me by the opposite party, and it is that information that prompted me to enter into the contract, my consent is given because of the wrong information furnished. Therefore, my consent is not given freely and voluntarily. But if he does it intentionally, in Telugu సామెత చెప్పగలరా? నీటిలో ఉన్న గాడిదని చూసి, గుర్రాన్ని చూసి, ఎద్దుని చూసి, లేకపోతే కావును చూసి బేరం ఆడదు. యాక్చువల్గా అయితే నీటిలో ఉన్న గేదెని చూసి బేరం ఆడదు. ఎందువల్ల? ఆ నీటిలో ఉన్న గేదె వారితో తెలియదు, ఏజో తెలియదు, యంగో తెలియదు. నెవర్ లెట్ ఇట్ కమ్ అవుట్, లుక్ ఎట్ ఇట్ అండ్ దెన్. ఎందుకంటే ఆల్ గ్రీన్ పాస్చర్స్, all distant pastures are always green. So If you are relying upon other party's description, other party is bound to give you truthful information. But let me caution you. Am I under a duty to tell all the defects in the goods which I am telling, which I am selling? I am selling this watch. There is some unfortunate fellow who wants to purchase. Should I tell him this watch runs only 5 minutes late per 1 hour? If I tell that, would anybody purchase it? So naturally, I will never tell the defects in my watch. Can you say, because you have not stated, other party has been misled, therefore this consent is not free? Now friends, please remember, there is no duty upon the seller of goods to disclose the defects in his goods. Let me make it very, very clear. If I am trying to, there is a case actually called pig's case, it is called. Pigs are suffering from fever. And the seller of the pigs never disclosed that the pigs are suffering from virus. Other fellow purchased. 2 days all pigs died. He filed a case saying that there is misrepresentation. He said, I never made any representation. Representation, please remember, can be made not only by words spoken, but by not speaking also. But not speaking or not uttering anything. Are you bound? If you are bound to speak and then you do not speak, it carries an impression. But when you are not bound to speak and you do not speak, you can't be bound for it. So here, the seller of the goods is not under a duty to disclose the defects. Therefore, if he keeps quiet, nothing wrong. But suppose the purchaser asks me, the fellow who is purchasing the watch asks me, is it running properly? Then I keep quiet. What does it mean? Even though I have not uttered even a sentence or a word, I am conveying the impression that the watch is running perfectly. That is a representation. If I am duty bound to speak and if I do not speak, maintaining silence on my part will amount to representation. And when I am not bound to speak, if I do not speak, silence on my part will never amount to representation. Because most of the times we assume that representation must be an overt act, a visible act like making a sound or a signal or a symbol. But silence also conveys an idea. But silence will amount to misrepresentation only when the person who is maintaining silence is under a duty to speak. If he is no more under a duty to speak, you can't find what is going on. This also kindly bear in mind. This is another important aspect. Please bear in mind, if it is intentional, it amounts to fraud. If it is unintentional, casual, reckless, careless, it amounts to misrepresentation. Both cases, please don't be carried away. Only fraud will vitiate the consent. Even misrepresentation will affect the consent. Because it is wrong information. Wrong information given by you, you may have very good intention in your mind. You may have noble intention of never defrauding me. But ultimately, I was led to enter into a contract because of the wrong information given by you. If you were to give correct information, I may not enter into contract at all. Or I may impose my own new terms while entering into contract. You prevented me from exercising my own free will and accord by misleading my mind by giving wrongful information. Therefore, that is undoubtedly ground for avoiding the contract on the simple plea that I gave my consent because of the false information furnished by the opponent. Either intentionally or innocently, does not make any difference. Okay. Then we go to the fifth important item. Fifth important element of reason or cause for lack of free consent. Coercion, undue influence, fraud and misinformation. Friends, mistake Fortunately, could be mistake as to law or mistake as to fact. Mistake of law. Can any person argue that this contract or this transaction is not binding on me because I have committed a mistake of law? Should we tolerate it? A person commits a murder and says, I do not know that committing a murder is contrary to law. What will happen? Everybody after committing a crime will come with the argument, wonderful argument that I do not know the law. And we all know ignorance of law is not an excuse. Therefore, even if a person entered into a contract under a mistaken impression that this is the law, contract is perfectly valid. Mistake of law will not affect the free consent. In spite of mistake of law, the consent given is free consent. I entered into a contract with a person of 16 years age, thinking that any person who is above 16 is also a major. But we all know that a person is a major only on attaining 18 years. Can I argue and say this contract is binding on the minor? Because I committed a mistake of law. I thought that a person becomes a major on attaining 16th year and not 18th year. I committed a mistake. Sorry. Even if I commit a mistake, this contract is binding on me because no person will be permitted to take advantage of his own mistake, especially when it relates to prohibition of law. Otherwise, what happens? Everybody will do something wrong and say, doing this is contrary to law. I do not know. Therefore, I am accepted. I cannot do this. Law and order can never be maintained. Peace and tranquility can never be enforced. Therefore, please bear in mind, mistake of law will have no effect on the consent. In spite of mistake of law, consent is freely given only. Mistake of law cannot be considered as a flaw in consent. Go to mistake of fact. Mistake of fact is two kinds. Both parties may be under mistake or only one party may be under mistake. So friends, honestly, if both parties have committed a mistake, is it fair on our part to impose the contract on them and say, even both of you committed a mistake, it's okay, you are both by it? So, bilateral mistake will amount to lack of free consent. Bilateral mistake will affect the validity of contract. If parties to the contract enter into it with a mistake, both parties are under mistake, then there is no free consent, there is no valid contract. Then we come to the real crucial one, that is unilateral mistake or one-sided mistake. So friends, for one party's mistake, should the other party suffer? Yes? Younger daughter Shonu, elder daughter marriage. సినిమా ఇస్తాం క్యాప్టెన్ పెళ్లి చూపులకు వెళ్ళినప్పుడు చిన్న అమ్మాయిని చూపించారు, అందంగా ఉంటారు. పెళ్లి చేసినప్పుడు పూలతో మౌనం కప్పేసి తాళి కట్టించారు. పెళ్ళి షాక్ చూసింది ఒకరిని చేసుకుంది ఇంకొకరిని. ఎలా ఈ పెళ్లి చెల్లదు అంటారు. ఇదే కాంట్రాక్ట్ అనుకోండి. ఏమిటో వాట్ ఈస్ షోన్ ఈజ్ వన్ థింగ్, వాట్ ఈస్ గివెన్ ఈజ్ ఎంటైర్లీ డిఫరెంట్. మ్యారేజ్ అయితే కాంట్రాక్ట్ అయితే ఎవరు మిస్టేక్ కమిట్ చేశారు? వీడు. ఈ తాళి కట్టే ముందు ఆ అమ్మాయి కథ చూసుకోవాలి కదా. అది చెప్తారే చెప్పండి, ఉంది కదా, చూసారా? బైక్ కనిపిస్తుంది. ఓహో, అంత అమ్మాయి ఇంకా దాంట్లో అనుభవించాల్సింది. So remember, unilateral mistake will not affect the validity of the contract. ఈ తప్పుకు నేను ఎందుకు బలి కావాలి? You have committed a mistake. Why should I? You saw something, you thought it's a higher value, you have agreed to purchase it. Why should I suffer? What? Bilateral mistake, it affects the consent. Unilateral mistake. Bilateral mistake, let me give you one beautiful example. Two traders entered into a contract for purchasing goods which are coming to India on a ship. Today they entered into contract. Now, around 10 a.m. Unknown to them, 9:30 the ship sunk. Along with the ship, the goods are also sunk. Now, is it possible to enter into the deal, fulfill the deal? If they were to know that the goods have disappeared because the ship was sunk, would they enter into contract? They gave their consent on the supposition that at the time they are entering into the contract, the goods are still there. When that disappeared, the very foundation of the agreement gets disappeared. Therefore, there is no free consent at all. But for one party, one party's mistake, why should I suffer? Because if you say your mistake must be accepted, contract is void. If the contract is void, I can't enforce it. For no mistake of mine, why should I suffer? If the contract is valid, you will suffer. Because you are bound by the contract. Since you entered into contract carelessly, having committed a mistake of your own. So friends, normal principle, let me assure you, is unilateral mistake will not affect the validity of the contract. Unilateral mistake will not be considered as a flaw in consent. In spite of unilateral mistake, a party that gave the consent because of unilateral mistake is still deemed to have given consent freely and voluntarily. These are the mistake of law, bilateral mistake, unilateral mistake is covered in section 20, 21 and 22. But then, take a simple case like this. Somebody comes to me. I am an aged person with a little bit of problem in eyesight. I am an illiterate. He comes to me and says, here is a document. I am taking loan from somebody. He is giving me loan. I am taking loan. This is a promissory note. Please sign as a witness. He is telling, I have taken the loan, so please sign. He made me sign. I signed on the revenue stamps. Because he made me to sign there. He showed me to sign there. Yes. He knows pretty well I am putting my signature as a debtor. Only I do not know I am signing as a debtor. I am thinking that I am signing as a witness. So error is committed by me. So for my error, should I suffer or not? Or should the contract be declared void? If the contract is declared void, I will be happy. If the contract is not declared void, he will be happy and I will be liable to pay because I have signed as a debtor under the promissory note. Normal principle is for my mistake, other party should not suffer. But there are some recognized exceptions under English law. Remind, please be careful. There are recognized exceptions under English law. Indian law does not admit any exception in either section 20 or 21 or 22. No exceptions for unilateral mistake. Under Indian law, there is exception for unilateral mistake under English law. But one good thing is, whenever Indian courts were called upon to deal with the matter, Indian courts have, we are the greatest importers. We have imported the exceptions from English law into Indian law. And basically, English law recognizes the following are the exceptions. Number one, when the unilateral mistake will identity of the contract party. See, the judges thought in one way. For entering into a contract, what is important? With whom I am entering into contract is important. What is the type of contract I am entering into? Is it an agency contract? Is it a sale and goods contract? Is it a partnership contract? Is it a construction contract? What is the nature of the contract? And third most important is, if I enter into this contract, what is the duty of me? What is my obligation? What is my policy? These are the things. If unilateral mistake relates to any one of these three, number one, identity of the party. Number two, nature of the transaction. Number three, nature of the promise. Three simple situations are mentioned. They said, because these three are essential for anyone entering into a contract, if one party commits a mistake about any one of these three, then it is a costly mistake. It is a mistake that must be considered. Even if only one party has committed the mistake, the contract is not validly formed, the consent is not given to be. Normal rule is, no person can take advantage of his own mistake. There are three exceptions when he can argue, because of his mistake the contract is not valid. Number one, if the mistake relates to identity of the other contract. Number two, the mistake relates to the nature of the transaction he is entering into. What is the transaction he is entering into? When I sign as a witness, I am signing on the document as a witness. On what transaction did I actually sign? Debt. As a debtor I signed. Therefore, this relates to the very nature of the transaction. Number three, what is the promise? By entering into this transaction, what is the duty I am imposing on myself? Because every contract creates an obligation. What is the obligation on me? What is the promise I am making? If there is a mistake about the promise I make, then it goes to the root of the contract. It is the essence of the contract. Where the unilateral mistake relates to the root of the contractual matter, then even if only one party is under mistake, it must be exempted. Otherwise, no person can take advantage of his own mistake. No person can argue that the contract is void because he is under a mistake. Excepting these three situations. Both are under a mistake, no problem. Mistake of law, sorry. But unilateral mistake relates to three. Yes. So friends, entire mistake, the three sections, I can place before you in four principles. First principle, mistake of law does not affect the free consent. Right? Second principle, unilateral mistake does not affect free consent. Third principle, bilateral mistake will affect the free consent. Fourth principle, unilateral mistake relating to A, identity of the party, B, nature of the transaction, C, nature of the promise will affect free consent. So two situations when free consent is not affected in spite of mistake, two situations when free consent is affected because of mistake. Four principles covered in three sections. In fact, fourth principle is imported from England. Therefore, we can understand in a easy way that number one, mistake of law, number two, unilateral mistake will not affect the free consent. A person who committed mistake of law, a party who alone committed mistake called unilateral mistake, cannot argue that because of that mistake, the consent given by him is not free. In spite of the mistake, consent given by him will be deemed to be freely and voluntarily given. But two situations when a person can take advantage of his own error. Number one, when it is unilateral, when it is a bilateral mistake. When two parties are under a mistake, therefore my consent is not free. Number one, bilateral mistake. Number two, unilateral mistake if it comes under the three exceptions. identity. Second exception, nature of the transaction. Third exception, nature of the promise under the contract. If his mistake relates to any one of these three, even though he only committed the mistake, he can take advantage of his own mistake. He can take benefit of his own mistake and argue that his consent is not given to the lady because of the mistake. Law says, okay, yeah. This is how you have to decide what is free consent and what is not free consent. Normally, whenever mistake is the root cause for giving consent, the contract becomes void. In all other cases, the contract becomes voidable and after the party whose consent is not given. Sometimes mistake is void, otherwise it is void. After mistake. Any questions? These are the second important essential element of a marriage contract, namely free consent.
So, mistake of foreign law is taken as
mistake.
If the party, if he knows the foreign law, then
if he knows the foreign law and despite no knowledge he enters into a transaction, then where is it from question of mistake? He knows the foreign law.
He knows the foreign law, but if he believes that he doesn't.
See that your statement he knows the foreign law has to be proved no. When he says that this contract is not valid because I am under a mistake, he has to prove that he has committed a mistake. Your argument says that he is aware of that law. He is now coming with the plea that he is not aware of the law. So is he aware or not is the actual question here. That depends upon the facts that are placed, evidence placed before him. But otherwise, suppose it is established he is aware of it, then his argument will not be accepted, the contract is binding. Suppose he says he succeeds in proving that he is not aware of it. That means he committed a mistake, unilateral mistake. Will it relate to nature of the transaction? Will it relate to identity of the party? Will it relate to the nature of the promise? Then, because of the mistake of foreign law, if any one of these three elements are affected, then unilateral mistake which is acceptable. We call it as operative mistake. Operative mistake because it affects the free consent. Only two situations are operative mistake. Number one, bilateral mistake. Number two, unilateral mistake covering under these three areas. Two non-operative mistakes. Mistake as to Indian law and unilateral mistake. Unilateral mistake under exceptions. Operative. Only unilateral mistake, non-operative. That's why the four principles, who specify when they become operative, who specify when they do not become operative. If it is operative, contract is not valid. If it is not operative, contract is valid. Now, suppose a person is already having two shoes. Is a third shoe essential? That's what is meant by provision of single shoes. Suppose a person is already having two shoes. Is a third shoe essential? Only one I find always essential is a saree for my wife. They will never say no. Always essential. That's the only exception. Therefore, you should not ask the question. Meaningless question at all. But accepting that, all other things, I am sure, you will have to take into account what are already available. Family background, property background, cash flow, availability of goods, and what is his social status. What is his social status? Suppose a minor is studying in Doon school or Doon institution. Naturally, he has to maintain some level now. But a minor is studying in municipal school, that much of level is not necessary. That is what is social strata. What is the social strata, what is the family background, what is the property, what is the cash flow, and what is the availability of similar items. Taking these five into account, you decide what is the condition of life of a minor. If this is the condition of a life of a minor, are these goods necessary or are these goods necessary? providing comfort for necessaries. If a contract is entered into, undoubtedly the contract is binding on the minor. Minor cannot avoid the contract on the ground of lack of confidence in you. So take these 5 information, keep that information in mind. As a reasonable man, you decide what will be his necessities. There can be biryani from Kamat restaurant, there can be biryani from Grand Bay. Biryani from Grand Bay is required for the minor who is Ambani's son. But the minor who is Rambabu's son, Rishabh, maybe Kamat biryani, even that is also what I say. So, at least bear in mind these factors and then decide what is. You are the judge. This information is placed before you. If this is the kind of minor, the goods that are taken by him by way of debt, credit, is it minor? Is it necessity? Is it a comfort? Is it a luxury? If it is for comfort and luxury, please remember it will not come under the definition of necessities. Therefore, the contract will not become valid. So there are wonderful cases. If you go to any textbook, you will find those cases. One fellow purchased a golden goblet and a ring and ball to give as a present to his girlfriend on her birthday. What is the cost? 100 pounds. What is his annual income? 150 pounds. If you want to spend money purchasing, you okay, but borrow. 150 rupees income per year, and this fellow for a girlfriend's birthday is giving 100 rupees. Well, is it necessary or luxury? So, court says nothing to do. It is not enforceable contract. It is void. Then, one fellow already having 5 suits, he goes for a 6th suit. Is it necessary? 5 suits are already there. So, 6th suit, they said it is not a necessity, but it is a luxury. So, friends, what goods are already there? What is this condition of life? Keep all that in mind and then decide. Okay. I always find one necessity for girls. Whenever I go, I always get a direction from my daughters. Get me chappals. And there Hyderabad Koti market, shop, ఎలా చుట్టూ కావాలో సెల్ ఫోన్లో ఎవరో కూడా ఆల్రెడీ 8 ఉంటాయి. 8 ఎప్పుడు వాడతాం, కానీ 9 కావాలి. ఎందుకంటే ఇది లేటెస్ట్ ఫ్యాషన్. సో ఈ చీరలు ఇవి వదిలిస్తే వాళ్ళకి నెసెసిటీ ఏమో నాకు తెలియదు. హౌ మెనీ ఆర్ ఆల్రెడీ ప్రొవైడెడ్ ఈజ్ నాట్ ఎ క్వశ్చన్ యాజ్ ఫర్ యాజ్ గర్ల్స్ ఆర్ కన్సర్న్డ్. I have not ever read. One person is there who is. So friends, keep in mind this basic information. Then imagine you are the judge. You are a reasonable person. You know the position of the minor. Is it a necessity or not? Your decision is as good as a judge's decision. Because you are a reasonable person. So suppose the goods are not necessaries. Then please remember what happens. Contract is void. If the contract is void, good. I am the minor, I take a bike on loan. I use the bike. I won't pay the monthly installment. Now when they file a case against me, I say, yes sir, this bike is a luxury for me. Therefore contract is not binding on me. I am not liable. Right? What to do? Court can't enforce the contract because the contract is void. And the courts have said in the BonafideVoices case, the contract is absolutely void. Absolutely void means no question of enforcement under any circumstances whatsoever. Then you know where a judicial intelligence comes. What the judicial intelligence? What is this contract between the minor and this trader? What? we move in void. What does void mean? Void means nothing is there. Nothing is there between them. If nothing is there between them, in whose possession the squatter should be?
The seller's position.
See, they have taken the word void and given a beautiful interpretation. If the contract is void, there is nothing there between them. If there is nothing there between them, the parties must be in the position in which they were before entering into this transaction. Before entering into this transaction, the squatter is in whose position? Trader. Give us. So they said you can take back the squatter. But sir, this has been used for 6 months. What about the use? It lost its value. It is 6 months back it is 40,000, now it has come down to 10,000. Oh sir, Sachin adequately. They have వచ్చిన సంతోషించా లేకపోతే నువ్వేమీ చేయలేవు నువ్వు ఇదేనా ఉంటే సంతోషించిన బాగుంటుంది అక్కడ కాస్త they prevented the minor from taking undue advantage of the law. This is where you come across a principle called estoppel. After entering into a contract, when a case is filed against me, what is my argument as a minor? I am a minor. Therefore, this is not a necessity. Therefore, this contract is void. Therefore, this contract is not enforceable against me. So, are you stopping the law or are you stopping the minor? The other will argue, the minor made a representation, he is a major. Now he is coming with the argument he is a minor. Once a person said he is a major at one time, he cannot go back and argue that he is a minor. Principle of estoppel operates. Now, unfortunately, court said principle of estoppel has no application against a minor. Why? Because it amounts to operation with estoppel of law. There can never be estoppel of law. But court said in this case, we use our discretion. Contract is void. Void means nothing is there. Therefore, the goods must be handed over back to the trader. That is how, to some extent, justice is done to the interest of the trader at the hands of the clever minor. Because the minor, even though he is a minor, he made a representation, he is a major, and then to the goods of it. Even in such case, the courts have used the expression void and its meaning to restore a semblance of equality to the parties and essence of justice is done to the trader. So this is about the mind. So the next requirement, sound mind. Who are said to be possessing sound mind? Friends, it is presumed that every human being is having sound mind. Hearty congratulations to all of us. We are all having sound mind. Okay? But then a doubt might arise in respect of some people, whether they have sound mind or not. Number one, insane people. Number two, who is the second person?
Lunatic person. Idiot.
Only one person, insane people. As far as mind is concerned, insane people and old people. Whether old people can be said to possess sound mind or not, let us take insane people. Friends, lunacy is a disease. As long as the person is suffering from lunacy, he doesn't possess sound mind. But lunacy is not a continuous disease. Before he is affected by lunacy, he is sane. After he is cured from lunacy, he is sane. But as long as he is suffering from the disease called lunacy, he doesn't possess competency to execute. But lunacy will be not a continuous disease. It will be an intermittent disease. So there will be an interval. During the interval time, he is again considered to be sane. So during the same period, he is entered into contract already. During suffering of insanity, he cannot do. That's what we waste most time about these people. Let's go to the next one. Old age people. Old age people, if it is proved because of the old age, if they cannot think on their own, they do not have functional mind. Friends, whether there is functional mind or not, two tests are required. Number one, is the person competent to understand the transaction? Can he assess how it is going to impact him? What is the nature of the transaction? How it is going to affect him? Anyone who is capable of making a judgment of these two is having something. Anyone because of age, because of disease, because of any other cause, he cannot make a decision of these two. Nature of the transaction, consequences of the transaction of him, then he will not have something. Next we go to the other one. Disqualified by law. Is a married woman competent to enter into contract? English law has a funny. On marriage, the female's personality gets merged with the male personality. Therefore, female cannot enter into a contract on her own. Ultimately, it is her own personality that remains. This fellow's personality will disappear. But here it is. English up to 1935, they said a married woman cannot enter into a contract in her own name. She has to enter into contract as Mrs. Kesavrao, not Lakshmi or Saraswati or Parvati. After 1935, they realized, don't think English people are forward in all respects. They are backward in most of the respects also. It is better to allow them to have their own personality. Therefore, they said after 1935, marriage is not a disqualification, it is a super qualification. You can enter into contract in your name and you can even pledge the credit of your husband. In India, fortunately, we have no such problems because Hindu women have their own property called Tridhana. So Tridhana property they can sell, they can acquire, they can lease, they can do anything with the property. So the disqualification that is there for English females, married women in England, is never there among the Hindu married. What about the barrister? Have you heard about barrister? Barrister law. Have you heard about it? Can a barrister law enter into a contract with a client for fees? Friends, barrister law is a 9 months course in England. In the 9 months, what they have to do? They have to attend 28 dinners, Saturday dinners. 28 must. One they must host. Whoever hosts the greatest dinner is university first. Whoever attends 28 dinner qualified and is given the degree bar. Really? Politicians, sons and daughters, and the leading advocates, IAS, officers, at that time they used to go to England and then get this degree. So this is an honorary degree, noble degree. They are supposed to argue the case for the sake of the client, Samaja Uttara. So the bar class will have about 4. Foundation a government America to pocket over. Bar class government America to pocket. Kakada pocket over. Case argue this like Galera. Client or you are able to America America is not they should not enter into a contract with the client or fees. Great person. Gandhi led one, double Gandhi other philosophy. But he was pocket and place near the gold. I have taken the gold pocket lane. So, no restriction as far as Indian advocates are concerned to enter into a contract with a client for fees. Of course, what fee rules you like? Are rules say? There are rules. I don't know. అంతా పాకెట్లే కాబట్టి ఫుల్ ముఖ్యచ్చు క్లయింట్గా తెలిసిన టీఎల్ పోయిన కోర్టు పోయిన అడ్వకేట్ తెలిసిన అడ్వకేట్ ఇద్దరు ఇంట్లో వెళ్ళి హ్యాపీగా కాలక్షేపం చేస్తారు. అది ఇంకో భార్య కాలక్షేపం లేదు. ఇంకా ఉన్నారు వైజాగ్లో కూడా ఉన్నారు భార్య వాళ్ళు లేకపోతే ఇంకా కొత్త వాళ్ళు రావట్లేదు. ఎందుకంటే ఈ రోజుల్లో డబ్బు సంపాదించకుండా సేవ చేసేవాళ్ళు ఎవరు ఊరికే కదా సేవ చేసేవాళ్ళు ఇంకెవరున్నారు మ్యారీడ్ భార్యలా ఇన్సాల్వెంట్ అంటే ఎవరు? అప్పులు తీసుకున్నది వాడి ఆస్తి ఏంటి ఎక్కువ ఉన్నవాడు, అది ఇన్సాల్వెంట్ అంటే. ఏ పర్సన్ హూజ్ డెట్స్ ఆర్ మోర్ దాన్ ది వర్త్ ఆఫ్ హిస్ ప్రాపర్టీ. ఈ అప్పు తీసుకుని ఇవ్వలేదట, ఈ కొత్త కాంట్రాక్ట్ మళ్ళీ ఎంటర్ అప్పు తీసుకుంటాడా, ఈ నెల వేయాలా? therefore an insolvent is disqualified from entering into contract. There are like insolvent petition convict fourth figure is also disqualified. Convicted person. So law break చేసినోడికి law fulfill చేసినోడిని ఇద్దరు ఒకలా చూస్తే ఏం చేస్తారు? మా ఇంటికంటే చేయలేదు, టైం ఫుడ్, టైంకి ఎంటర్టైన్మెంట్, టైం స్లీప్ అన్నీ ఉంటాయి కదా. సో అందరూ అక్కడే ఉంటాం కాబట్టి one important disqualification is as long as a person is a convict, that is undergoing sentence because he committed a crime, he is disqualified from entering into contract. Suppose he is pardoned or he completes his term, he is a normal citizen like you and me, he can enter into contract. But a person, a convict who comes on parole, he is still a convict, therefore he is disqualified from entering. Now to the other person, that is artificial person called corporation. Friends, corporation always comes into existence because of certain fundamental documents. One such very important document is Memorandum of Association. Memorandum of Association has a clause called objects. A company is competent to enter into contract only for the objects mentioned in the objects. They are called intra-vires. If a company enters into a contract for the purposes mentioned in the object clause, the contract is said to be intra-vires. Suppose the corporation enters into a contract for a purpose which is not stated there, it is called intra-vires. So, what is the competency of a corporation? A corporation can enter into a contract only for the objects that are mentioned in the objects and for none else. There cannot be a contract of marriage between Hindustan Shipyard and PhD, like between two human beings. But there can be a contract of sale of some items between Hindustan Shipyard and PhD. That's not a disqualification. Because such transactions can definitely be entered into as they are in tune with the objects of disqualification. Can Hindustan Shipyard manufacture aeroplanes for Malaysian Airlines? Hindustan Shipyard entering into a contract for manufacturing aeroplanes for Malaysian Airlines. నేను ఫ్లైట్లు ఎలాగో నీటిలోకి వెళ్తున్నాయి కదా, మా షిప్పులు నీటిలోనే ఉంటాయి, తేడా ఏంటి మేము కట్టేస్తాం, ఎలా చెప్పుకుంటే బిజినెస్ లేదు అని ఎంటర్ అయ్యారు కాంట్రాక్ట్. వచ్చా చెప్పండి.
ఎలిజిబిలిటీ
ఒకప్పుడు ఇదే ఎగ్జాంపుల్, ఏపీఎస్ఆర్టీసీ బస్సు వాడేవాడు. ఆ బస్సులు ఎప్పుడు కూడా ఇంటిని గుర్తించి మరీ ఇంట్లోకి వెళ్ళిపోతుంది. సో ఏపీఎస్ఆర్టీసీలో బస్సులు కట్టడానికి కాంట్రాక్ట్, ఎందుకంటే షిప్పులు కట్టడానికి ఆర్డర్ ఇవ్వలేదు. Because the objects clause does not specify manufacturing of aeroplanes as one of the objects. If a corporation enters into a contract which is not stated in the objects clause, the main contract is void. Even collateral contracts become void. What is the example I gave? Hindustan Shipyard entering into a contract with Malaysian Airlines. For what? For manufacturing aeroplanes. Now, for manufacturing aeroplanes, some infrastructure has to be made. For that, they borrowed, let us say, 20,000 crores from ICICI Bank. Please remember, ICICI Bank cannot recover even a pie from Hindustan Shipyard, because the loan is given for a purpose which is not specified in the memorandum. Therefore, the purpose is ultra-wise. When a loan is given for a purpose that is not ultra-wise, the loan cannot be recovered. Not only the main contract, but even the collateral contracts will be totally affected. That's a specialty. Why should we study? Otherwise, it's common sense. That if when an artificial person is bound for certain purpose, for that purpose, you can always enter into a contract. Nobody need to tell us this point. But what will happen if it enters into a contract for a purpose which is not stated? Not only it becomes void, but all connected collateral contracts also become absolutely void. What about partnership? Partnership is, remember, cannot enter into a contract in its own name. It has to enter into a contract through its partners. So it is as good as an individual entering into a contract. It's not like a corporation, because a partnership is not an artificial body. Independent existence is not there. It and its members are one and the same. But now, in the latest, we see a new kind of partnership has come. It is called limited liability partnership. Well, if it is a limited liability partnership, it is given power to enter into contract in its own name. It is according to the Limited Liability Partnership Act. This is a new invention. And also remember, the new Companies Act of 2013 came out with a new concept called one-man company. It is called OPC, one-person company. One-person company, OPC. How can there be one-person company? Because company means only many people. And even one-person company is permitted. If one-person company is formed, the company will have its own separate legal entity. It will have its own artificial person like any other company. It can enter into contract not in the name of the owner. It can enter into contract in its own name. In the one company's name only, the contracts are made. These are the two developments. One-person company can enter into contract in its own name. Limited liability partnership also can enter into contract in its own name, like a corporation or a company. But an ordinary partnership formed under the Partnership Act, it has to enter into contract through its partners, not individually. In its own name, it cannot enter. And always only from the purposes for which the partnership or the one-person company has been. This is a more complicated. Intoxicated person is not competent to enter into contract when he is under the influence of drink or drugs. Because at that time, he doesn't have mind in his own. That's the way. But there are some people who are saying only after they get intoxicated. If they don't get intoxicated, they can't even stand. So for those people, it's not a problem. And unfortunately, we are under the impression any person who takes a drink is intoxicated. No. Intoxication is such a disease where, because of the influence of the alcohol on the mind, he is unable to know what he is doing and he is unable to assess how it is going to affect him. He cannot be set off. when he reaches that state, varies from person to person. That's why if you see, take any foreign agreement between two prime ministers of two countries or two presidents. If you observe carefully the TV clipping, they are always holding the glass in their hand. They are drinking. It may be wine or it may be some other intoxicated drink, but they are drinking. Go down the road. And many major contracts are settled over drink. Afterwards they are written. But at that time, there is every possibility that one person may be sober, one person may not be sober. So, if at the time of entering into the contract the person is intoxicated, contract is void. But in such case, what happens normally is, today night they enter into contract in a drunken state, next day morning after becoming sober they ratify. So when they ratify, it will have effect from the time of ratification, not from the time of actual agreement. In case of big contract between two corporate leaders, well, there will be every possibility of they reaching an agreement in a drunken state. But that doesn't matter because the agreement is reached after becoming sober. But by any chance if a person enters into a contract when he is in intoxicated state, contract is good. The elements of formation of a valid contract. The first one is agreement, second one free consent, third one competency arbitration. Let's go ahead to the fourth one, considerations. Friends, entire law of contract tells us when a person is bound to fulfill the promise he makes. The other way is when a person can make a promise and get away without performing. Can all promises be enforced? Should a person fulfill every promise he makes? Is it possible for every person to fulfill every promise he makes? It's not practically possible. Therefore, law of contract tells us what promises you are bound to fulfill, what promises even if you make, you need not fulfill, and if you don't fulfill it, you will face no consequence. The simple test that was invented was how to find out the seriousness of the promise. Was the promise made seriously? Was the promise made casually? If it is a seriously made promise, a person must fulfill it. But if it is a casually made promise, he may not fulfill it. If he doesn't fulfill it, there is no consequence at all. Law will not punish him. Law will not make him suffer in any way, even though he did not fulfill it. How to find out the seriousness? Traditionally, Roman law and English law came out with form. What is the form the parties have followed for reaching a promise? That is why English law divided contracts only into two categories: simple contracts, special contracts, or contract of speciality. What is a simple contract? I will tell after I tell what is a contract of speciality. Contract of speciality is a contract which was entered into by parties following certain formalities. They are also called formal contracts. Four formalities. Number one, writing. Number two, signing. Number three, sealing. And number four, delivery. When the agreement is signed, written, signed, sealed and delivered, who will go through this entire process? Only those people that want to seriously be bound by the promise they make. So when the parties go through these four important steps, it indicates seriousness on the part of the parties. Therefore, all contracts of speciality or formal contracts are enforceable. What about others? Please remember, contract need not be in writing. Even orally parties can enter into a contract. What about an oral contract? If parties take the trouble of following these four formalities, excellent. It shows seriousness on their part. But what about all others who enter into contract by word of mouth. Then they said all other contracts called simple contracts. They are also called oral contracts. They are also called payroll contracts. In fact, it is better to call them as contracts other than contracts of specialty. Formal contracts, non-formal contracts. Non-formal contracts are valid and enforceable only when they are supported by consideration. That is why there is a famous saying, an agreement without consideration is void. If there is an agreement between the parties, if it is unfortunately not supported by consideration, it is void, because presence of consideration indicates the seriousness of the promise the parties make. For this they followed, rather they derived the base from Roman law. In Roman law there is a concept called quid pro quo. That is something in return for something. You can enforce the promise I make when you purchase my promise. All we can do is the whole philosophy of consideration. You can make me bound by the promise I made if you purchase my promise. If you don't purchase my promise, I am not bound to fulfill the promise I make. How do you purchase my promise? By paying something in return. Therefore, quid pro quo, something in return for something. And a promise without supported by consideration is a naked promise, and it is not enforceable. In order for a promise to become enforceable, it must be clothed by consideration. Ex nudo facto non oriter actio. Out of a nude agreement, no action arises. But if the agreement is clothed with consideration, the agreement becomes a contract, it becomes valid, it becomes enforceable in a court. That is how the necessity of consideration for an agreement to become a contract has come into existence. Formal contracts, no problem. Informal contracts will derive their validity only by the presence of consideration. That is why in section 25, in simplest possible way, the principle laid down is an agreement without consideration is void. In fact, in the entire Indian Contract Act, that is the shortest sentence. No other sentence is more shorter than this. Agreement without consideration is void. Friends, consideration is a must, except for formal contracts. Parties who write the agreement, who sign the agreement, who seal the agreement, and who deliver the agreement, that's an exception. But otherwise, all contracts will derive the validity only when they are supported by consideration. This leads us to the next question. What is consideration? What is consideration is given in section 2 clause E. It's a very lengthy definition. Don't be carried away by the length of it. It's a very simple definition in spite of its length. When at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act as necessary or promise is called consideration for the promise. The best way to understand this entire definition is by asking a few questions. Who should give consideration? When consideration must be given? What must be given as consideration? How consideration should be given? If all these 4 questions are answered, we know everything about consideration, because we know the answer for the first question. Why consideration? Because presence of consideration indicates the seriousness of the promise, and it becomes a legally enforceable promise. So, who should give consideration?
Promisee or any other person.
Promisee or any other person. That means a person who is a party to the contract need not always furnish consideration. Consideration can be given by a third person also. Let me take a small illustration. When A told B, I will give my pen, and C told A, you give me pen, I will give you pen. Here A is making a promise promises I'll give the pen, which promises I'll take the pen. Unfortunately, B is not paying the 10 rupees for B. On behalf of B, C is paying the 10 rupees. Is it valid or illegal? At the desire of the promisor, the promisee, who is the promisor in our example? A. Who is the promisee in our example? B. So at the desire of the promisor, the promisee gave to B or any other person can give consideration. In other words, consideration given by a third person is perfectly valid under Indian law. Okay? Clear? Suppose C has already given 10 rupees. A did not pay the pen, give the pen to B. Money is received, pen is not given. Who can file a case?
B alone should.
Can C file a case?
No, no. Stranger to contract.
Here you have to understand two simple concepts. One is called stranger to contract, another is called stranger to consideration. Here between A and B there is a contract. C only came and said, I am happy you are giving the pen to him, give the pen to him. He need not give it 10 rupees, I will give 10 rupees. Therefore, the transaction is between A and B. Therefore, A is a party to contract. B is also a party to contract. What about C? Is C a party? Contract is between whom? Agreement is between whom? A and B. Therefore, C is a stranger. We call him as a stranger to contract. Now, if A is a party to the contract, B is a party to the contract, and C is a stranger to the contract, who can file a case against A if A doesn't deliver the pen? Only B can file a case because contract always creates a rights in personam. The rights under a contract are available only to the parties. No third party can acquire right under a contract. C being a third party, he is a stranger to the contract. Therefore, C cannot file a case against A. Only B can file a case against A because the original agreement is between A and B. But please see. Who gave consideration in this example?
C.
A gave consideration. A is giving pens. Consideration there will be quid pro quo, something in return for something. A is giving pen. Therefore, A is party to consideration. Who is giving the 10 rupees in return? C. C is party to consideration. What would be? Has he given anything in return? What is the consideration for pen? 10 rupees. Has B given it? No. Therefore, B is considered as the stranger to consideration. Who can file a case? B. In other words, Indian law permits even a party who does not supply consideration to sue. Stranger to consideration can sue in Indian law. Stranger to contract cannot sue because who is a stranger to contract here? C. C can never file a case against A. B can file a case against A. A's argument, B has not given the consideration to me, will not hold water. It is not valid because Indian law two simple principles. Stranger to contract can never sue. Stranger to consideration can sue. But Indian law is slightly different from English law. What does English law say? English law says consideration must be given by the party only. No third person can give consideration. If the deal is between both of us, I should give him something, he should give something in return to me. No third party. Because third party is only giving out of grace. It is Special love and affection is giving, therefore we don't take it into account. Out of gratitude he may be giving, we don't take that into account at all. So English class is stranger to consideration cannot sue, stranger to contract also cannot sue. Whereas Indian law is on par with English law in one principle. Stranger to contract cannot sue both under Indian and English law. But Indian law differs from English law in one respect. What is it? Stranger to consideration cannot sue under English law, whereas stranger to consideration can sue under Indian law. Because definition clearly permits furnishing or giving of consideration not only by a party to the agreement, but even by third party. That is why when at the desire of the promisor, the promisee or any other person means consideration can be given either by the promisee or on behalf of the promisee by any third person called stranger to contract. But he cannot sue because he is a stranger to law. Be now example. Even though he never gave consideration, because he is a party to the agreement, he will always sue. So stranger to consideration can sue, but a stranger to contract can never sue. Any questions for me? Something is wrong with this room, no?
It's very hot, sir.
Sweating.
Hot, sir.
Heart is okay. Anyway, we have to manage the kind of weather we have to face. Any questions? Then we go to the second aspect. When consideration must be given. Consideration must always be given at the request of the promisor. If I do something voluntarily, whatever I have done voluntarily and not at your request will never become consideration for your promise. I normally give this example. Two people are walking. One person's attention is elsewhere. A car is coming in a very speed, very fast, and an accident is likely to occur. His friend saved him, pulled him. Luckily, accident escaped. Well, at that time, the friend that is saved told the other person that has saved him, I am going to give you 1,000. So he made a promise to give 1,000 rupees. For the promise to give 1,000 rupees, what is it that he got in return? Help. Saving. He was saved by him. As he asked his friend to save him. So saving, which is the consideration for the 1,000 rupees promise, was not done at the request of the promisor or at the desire of the promisor. Therefore, anything voluntarily done by me without your request can never become consideration for your promise to give me something. Because clearly it says, even the definition starts from this. When at the desire of the promisor, only when the promisor asks you to give something, if you give that something, it becomes consideration. Without promisor's request, if you do something voluntarily, that will never become consideration for future promise. So consideration must be given at the request of the promisor. Consideration can be first, promise can be next. No problem. You may ask me how and why. Go to the third part. Third part tells how consideration can be given. When at the desire of the promisor, the promisee or any other person. From this part of the definition, we have derived two principles. What is it? Number one, consideration must always be given at the request of the promisor. Number two,
Consideration should be
Consideration
given by promisee or any other.
may be given by the promisee or it can be given by any third person. So go to the third part. When at the request of the promisor or desire of the promisor, I am going with the definition. Promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or to abstain from doing. That means has done to the past. Is being done, present, or promises future. In other words, consideration may be past, present or future. Whatever given by me yesterday can be a consideration for the promise you make today. Whatever I am giving today can be consideration for the promise you are making today. Whatever I am promising can be consideration for something which you are going to give tomorrow. So consideration may be past, may be present, or may be future. But remember, it must always be at the request of the promise. Once again, the saving example. It was past consideration, saving first and promise next. Therefore, it is undoubtedly past consideration. But even though it is past consideration, even though it is valid, please remember it was never done at the request of the promise. Therefore, past consideration given at the request of the promisor is valid. But past consideration given voluntarily will never constitute valid consideration for a subsequent promise. Okay. Please remember this aspect. Then go to the fourth part. What must be given? Number one, when must be given. Number two, who must be given. Number three, how it must be given. And number four, what must be given. What must be given? Something must be given. What does that something mean? When can you say that one person has given something to another? The statute simply says, the definition says something. When at the desire of the promisor, the promisee or any other person has done or abstained from doing positive or negative, or does or abstain from doing present positive or negative, or promises to do or to abstain from doing future positive or negative. What? Something. Something I must give. What does something mean? Let me caution you, something does not mean adequate. If I am telling you a pen that is worth 100 rupees, it is not necessary you must give me 100 rupees. Even if you give me 1 rupee also, that 1 rupee is something in return for the 100 rupees what can I do? Please remember, adequacy of the bargain is not the duty of the court. Adequacy of the bargain is for the parties to decide. For how much my pen I must sell, who is the competent to decide? Me. Whether my pen that is worth 100 rupees I should sell for 1 rupee or 10 rupees or 100 rupees or 1000 rupees is for me to decide, not the court. The courts have said, we are not here to make bargains for the parties. It is for the parties to make bargains for themselves. We do not interfere in the bargain as long as something one party is getting in return for what is given. But the court said, something need not be adequate, but something should not be illusory. I am taking 5 lakh from you. I have taken 5 lakh from you, saying that I will create treasure by magic, or I will make 2 parallel straight lines meet, or I will bring life into a dead body. These are impossible things. They are illusory. They can never happen. If I make such promises, well, they can never constitute something in return. You are getting virtually nothing, because you can never get it. Putting life into a dead body is impossible. Making 2 parallel straight lines meet is impossible. And creating treasure by magic is also impossible. So what you are promising is something which can never happen, which can never be made to happen. So in such case, the courts will say the consideration is nothing, because it is illusory and impossible. Therefore, it is not valid consideration. So friends, something must be done. Now very peculiar questions are come, because I am already duty bound to do something. I promise to do that. Will that constitute consideration for this promise?
No.
This is called performance of pre-existing obligation. Performance of pre-existing obligation. Imagine I am a lawyer, you are a client, you have entrusted your case to me. I have to argue. My duty is to present your case to the best of the merits of the case and to my best of my ability. I am not appearing before the court. You come and tell me, sir, please represent my case, I am going to give something extra. Original fees is 5,000 rupees, now the additional fees is another 2,000 rupees. Now I appeared and afterwards you have not given 2000 rupees. Can I recover the 2000 rupees? For that 2000 rupees, have I done anything extra? I only did what I am already legally bound to do. I only performed a pre-existing obligation. I have not done anything extra. Therefore, sorry, here something in return was never given. For your promise of giving 2000 rupees more, you have not got anything extra from me. What I did was what I am already bound to do. Similarly, imagine I am a witness. I am summoned by the court. I have to go to court as a citizen. It's my responsibility and give evidence. Well, one party comes and says, please don't miss from coming to the court. Please come to the court and give evidence. I will see that your efforts are compensated. Because you have to apply for leave, you have to spend some money for travel, you have to pay there for the whole day. Naturally, those expenses I will reimburse. I went, did my job, I asked for the promise of reimbursement and they said thank you very much. Am I entitled to get the promise of reimbursement? That is 1,000 rupees he said he will give. Can I get that? Can I get the 1,000 rupees? This is a simple question. Friends, I am not entitled to get because I have not done anything more than what I am already bound to do. Lawyer is already bound towards the client to discharge his services professionally. Every citizen is bound to the state. There is a duty owed to the state to fulfill his duty as a witness when summoned by the court. I have not done anything special. I have not suffered any extra responsibility, extra liability. I only did which I am already bound to do. Even if this promise were not to be there, I should have done it. Therefore, the court said, because you have not done anything extra, you have only performed something which you are duty bound to perform to other party or to the state. Nothing special was done by you. The party who promised did not get anything in return. Therefore, when something is not given, your promise is not bound to be fulfilled and you are not entitled to get anything from it. Very famous cases, Ramachandran Chintamani versus Kaluraju and Godfrey versus Williams. These are the two famous cases, kindly bear it in mind. And because this is one area where clarity is not there. Because depending upon each case, the courts will be pronouncing whether what is given in the agreement is something or not. So there is a possibility of some question being asked. So kindly bear this in mind. Something means something new. It need not be added. It must not be impossible. It must not be illusory. It should not be something which you are already duty bound to do. If you have done something which you are duty bound to do, you have already bound, therefore yourself doing it is nothing great, nothing special, nothing extra. Therefore the party who promised has not got anything extra. Hence there is no consideration for other person's promise, hence it is not enforceable here. Okay. But there is one case which you must remember because it's a very nice distinction. A classic distinction was made by the court itself. The judge has used his wonderful imaginative ability to come out and say whether there is something in return or not. This case is known by the name Shadwell versus Shadwell. Very famous English case. Well, one person is already bound to marry a girl. Engagement also has to be. It's only performance of marriage. One distant relative of the girl comes and tells, or the boy comes and tells the boy, I am happy to know that both of you are engaged. If you marry her, I am going to give you some, let us say, 10,000 pounds. He wants to express his happiness by giving some money. So he made a promise to give 10,000 rupees. The boy marries the girl. The boy married the girl. The boy asked the uncle to give money. Uncle said, thank you very much. Now the question is the uncle bound to pay that money? The argument by the uncle is, I have no doubt made a promise to give you 10,000 pounds, but for giving the 10,000 pounds, what is it? He is it extra. He is already duty bound to marry the girl because the engagement has taken place. He has not done anything special other than marrying. Therefore, there is no something in return. When there is no something in return, I need not fulfill my promise. This is the argument. So friends, this is where the cleverness of the judge comes in. I would say this is one of the very beautiful judgments. Now please, boy is already engaged to marry the girl. Suppose boy doesn't marry. What will happen? This is a question the judge asked. Suppose the boy does not marry, what will happen? The girl will file a case. Right? That means he will be exposed to liability, detriment. He will be suffering because of the court proceedings. Okay. Now this uncle came into picture. Between uncle and the boy there is a contract. By virtue of the contract, the boy is bound to marry the girl. Now suppose that he doesn't marry the girl. Can uncle file a case against the boy? Breach of contract. The girl can file a case against the boy for breach of engagement to marry. So how many cases can be filed now? 2 cases. Earlier, suppose uncle is not in the picture, only one. Because the uncle came into picture and because of this promise, the boy is exposed to 2 litigations. If the uncle were not to come into picture, the boy would have been exposed only to 1 litigation. Is it not detriment? Is it not suffering? Is it not more responsibility? Therefore they said, consideration need not always be in the shape of a benefit to somebody. Consideration can be in the shape of sufferance, loss, detriment to one party. If there is no presence of uncle, only one side slapping. Because uncle has come into picture, girl will slap one side, uncle will slap another side. 2 slaps. So friends, I am sure you will agree with me. One slap is definitely better than 2 slaps, and 2 slaps are definitely more detrimental when compared to 1 slap. This is the wonderful logic the judges come out, and they said, here the duty to marry is owed to a third party because the girl is the third party and the contract is between the uncle and the boy. When a duty that is owed to a third party is performed, it is something. Because if he doesn't do it, he is exposing himself to 2 cases. Friends, performance of pre-existing obligation owed to the other party, owed to the state, nothing special. But performance of a duty owed to third party, because it exposes him to more detriment, well, it is considered to be a valid consideration, and they said the uncle is bound to pay the 10,000 pounds to the boy because the boy married the girl. If he were not to marry, he would have been subjected to 2 different cases, which if the promise were not to be there, he would have been exposed to only 1 case. The second case is something detrimental. Therefore, detriment or benefit both amount to consideration. Hence, here the promise of the uncle is supported by consideration. Hence, it is perfectly enforceable and the uncle is bound to pay that amount to the boy. This is the special meaning of the word something. Something does not mean doing something which you are already bound towards other party, doing something which you are already bound towards the state, but it means and includes doing something which is owed to a third party. The girl is the third party because you are now concerned with the contract between uncle and the boy. The boy is trying to recover the 10,000 pounds promise made by the uncle. Therefore, they are the parties to the contract. Boy is already owed a duty to marry the girl. If he doesn't perform it, he will be facing music from 2 angles. And therefore, the court said it is perfectly valid consideration and it is enforced. Any question? This is about the definition. 4 principles. Number 1. Consideration may be given by the promisee or any other person. Number 2, consideration must be given at the request of the promisor only. Number 3, consideration may be past, present or future. Number 4, consideration must not be illusory, must not be impossible. It must be real and of some kind. Especially, performance of a pre-existing obligation owed towards the third party constitutes valid consideration, whereas performance of a pre-existing duty owed to the other contracting party or owed to the state do not amount to consideration. This is about the definition given in section 2. Normal principle is an agreement without consideration is void. Consideration, as explained in section 2D, must be present in every contract. Well, in India, a contract without consideration or an agreement without consideration is void. Whereas in English law, even if there is no consideration, it is a formal contract, like written, signed, sealed, and delivered. Even if it is not supported by consideration, it is perfectly valid for the condition. No friends. Please remember, section 10 tells agreement supported by consideration becomes a contract. Section 25 also declares in unmistakable terms that an agreement without consideration is void. But for this, there are 3 important exceptions. Indian law recognizes only 3 situations where a promise becomes enforceable even if it is not supported by consideration. First one, agreement between parties standing in near relation to each other in writing entered out of love and affection. A father gives a gift to the daughter or to the son. What is he getting in return from the son? Parties are in near relation, their agreement is in writing, and it is given out of natural love. When it is in writing, when it is registered, when it is between parties who are standing in near relation, and when it is entered out of natural love and affection, consideration is not necessary. That is why all gifts are valid. Why gift is valid? Gift is also a transaction taking place between two people. But then the person who gives the gift will not get anything in return from the person who gets the gift. Yet it is perfectly valid because that is the first exception created under section 25, where though in general consideration is essential, in 3 situations consideration need not be pressed for. First one is when it is an agreement entered out of open definition. Please remember, it must be in writing, it must be registered, it must be between relatives, it must have been entered into out of natural law. Second exception, promise to pay a time-bound debt. We know pretty well that promissory note is valid for 3 years from the date of execution unless it is extended by the date of acknowledgement. After 3 years, can a person go to a court? After 3 years, the debtor came forward and told the creditor, even though the promissory note is time-bound, I now promise to pay. So he is now promising to pay. But what is it he is now getting in return? But last is, even though you are now not getting anything in return, at one time you got the entire debt. The original money is given under the promissory note is still there. If you don't go to your court within the prescribed time limit, what is lost is your remedy. Your right is not lost. So your right to recover money is there, which money was given. That constitutes consideration for the fresh promise made after the promissory note is time bound. Third exception. In fact, I gave that example. 2 friends are walking, accident, one person saved. What is it he done? Voluntarily he did something. When? Before the promise was made, therefore we call it as past voluntary act. Saving the fellow was done in the past. It was done voluntarily because it was not done at the request. promise is made to compensate for the past services rendered voluntarily. Here the friend that is saved is making a promise to the friend that saved him. Thanks for saving me, I am going to give you 1,000 rupees. He is promising to compensate for the past services rendered voluntarily. Therefore, it is third exception. Please see carefully, read section 25 and section 2D. Past consideration is valid. Therefore, past act done at the request of the promisor valid according to section 2D. Past act done voluntarily is valid according to section 45, clause 3. Therefore, past act, whether it is done voluntarily or at the request, it is valid consideration for a subsequent promise that is made. 3 exceptions. Number 1, agreement between parties entered out of natural love and affection. Number 2, agreement to pay time bound debt. Number 3, agreement to compensate for past services rendered voluntarily. Excepting in these 3 cases, in India, whenever you want to enforce an agreement in a court of law, you must prove that there is consultation. If you can't prove the presence of consultation, the agreement becomes unenforceable in a court. This is about section 25 and section 20. Any questions? Friends, unfortunately, the consideration is used in 2 different contexts. 1, consideration in the formation of a contract. Number 2, consideration in the discharge of a contract. Let me tell you. So far, what all we have discussed today, it is only about consideration in the formation of a contract. It is not about consideration in the discharge of a contract. How consideration may come as a question in discharging of a contract. Imagine I owe you 1,000 rupees. I offer and say I give you 700 rupees, please write off the remaining 300. Final settlement. You accept. I give the 700 rupees. Can you file a case against me for the remaining 300 rupees which I have not paid, which you have agreed to forego? You have agreed to forego. Forget about the remaining 300 rupees. What is it you got in return? When a person is getting lesser sum, in satisfaction of the entire debt, for the balance of sum that has to be paid, what is the consideration that is here? Because remember, there is a new agreement. What is the new agreement? I will not ask for the remaining 300 rupees. I am foregoing the 300 rupees. What is the consideration you got? Friends, when the matter went to English courts categorically said, consideration is essential not only in the process of formation of a contract, consideration is equally essential in the process of discharge of contract also. So for the remaining 300 rupees, if you have not got anything in return from me, sorry, you need not go back. You need not stick to your promise. You can go back on your promise not to press for 300 rupees and now you can file a case against me. I will have no option. Because your promise to forego 300 rupees has not been purchased by me. Suppose I give along with the 700 rupees this chalk piece. 700 rupees and chalk piece is given. Please remember, this chalk piece becomes the consideration for the promise to forego 300 rupees. Okay, what is it? Ulu petyamu ani. Ulu petyamu endukante second double chevlo proof pettadu annamata. Aa proof consideration ekkudu. Second amount. సామెత ముందుకే రావాలి ఆచార్య వ్యవహారాలు బట్టి వస్తాయి. ఆ చెవిలో పువ్వు పెట్టడం అంటే మర్చిపోరా బాబు, పువ్వులు ఎప్పుడైతే పెట్టించామో పువ్వు యాక్సెప్ట్ చేసాడో ఏదైతే ఎక్స్ట్రా ఇస్తామో డబ్బులతో పాటు ఏదైతే ఎక్స్ట్రా ఇస్తామో అది ఏ అమౌంట్ అయితే ఫోన్ పోయిందో దానికి ఖర్చు. ఇస్తానంటే చాలా ఇంగ్లీష్లో పెట్టాలి. యాక్చువల్లీ ఇట్ మస్ట్ బి గివెన్ అంటే 700 రూపాయలు చాక్ పీసు రెండు ఇచ్చేయాలి. అంతేగాని 700 రూపాయలు ఇచ్చేసి చాక్ పీసు రేపు ఇస్తారంటే కుదరదు. ది కన్సిడరేషన్ మస్ట్ బి స్పాంటేనియస్. At the time of giving the 700 rupees, along with it must be given, it must be executed, it must not be executed. What about Indian law? In Indian law, there is no problem because Indian law categorically declared acceptance of lesser sum as equal to the total amount is valid acceptance. అంటే మనం పువ్వుల్లో పెట్టేవారు మామూలుగా మొహాన్ని కొట్టిస్తే అదే మహాప్రసాదాన్ని ఏరుకుంటే వాడు ఏరుకుంటే ఆ తగ్గింది ఏదైతే మనకు ఇవ్వలేదో కానీ వాడు వదిలేసుకున్నట్లే లెక్క ఆ అగ్రిమెంట్ వాడి మీద బైండింగ్ ఆ ఏ అమౌంట్ అయితే వాడు కోల్పోయాడో దాన్ని వాడు నా మీద క్లెయిమ్ చేయాలి. దిస్ ఈస్ స్పెషల్ ప్రిన్సిపల్ యాజ్ పర్ ఇండియన్ లైసెన్స్. Indian law does not insist on presence of consideration while discharging the agreement. English law insists that consideration must be present not only in the process of formation of an agreement or contract but also during discharge. Indian law payment వచ్చేసరికి సెక్షన్ 63, 64, 65లో క్లియర్గా చెప్పేశారు. Acceptance of lesser amount in satisfaction of the total debt is conclusion and final. ఒకసారి మీరు హీరో అయిపోయి ఆ పర్లేదండి అని చెప్పి తప్పు యాక్సెప్ట్ చేసిన తర్వాత విలన్ అయిపోయి నా మీద కేసేస్తారని చెప్పుకోవాలి. ఇది ఇవాళ హీరో ఆ విలన్ అయితే ఫస్ట్ నుంచే నాకు మొత్తం ఉంటుంది. పర్లేదంటే నా విశాల హృదయం 700 వస్తే చాలులే 300 మర్చిపోని అంటే మాకు మరెవరు మర్చిపోవాలి. మళ్ళీ దాంతోపాటు ఊళ్ళో పెట్టించాడా ఆకుల్లో పెట్టించాడా రాయి ఇచ్చాడా అనేది కాదు. ఏమి ఇవ్వకపోయినా పర్లేదు. ఇంగ్లీష్ లాలో మాకు ఏదో ఒకటి. ఎందుకంటే ఇంగ్లీష్ లా యాజ్ వెల్ ఇండియన్ లా ఆల్వేస్ ట్రీట్ దట్ కన్సిడరేషన్ నీడ్ నాట్ బి యాడింగ్ రేట్. 700 రూపాయలతో పడి చాక్ పీస్ ఇస్తే చాక్ పీస్ మీ ప్రకారం 300 పడుతుంది. కోర్ట్ ఈజ్ నాట్ ఇంట్రెస్టెడ్ ఇన్ మేకింగ్ బార్గెన్స్. ఈజ్ ఫర్ ద పార్టీస్. In Indian law there is no problem. It is categorically declared keeping the Indian conditions in mind. Acceptance of a lesser sum is virtually writing off the entire debt. No case can be filed for the balance of the loan on the ground that consideration is not due for the balance of the debt. This is what the consideration in the formation of contract consideration is. చేయమనండి యూనివర్సిటీని ట్రై చేస్తాను. ఎలా ఎందుకు ఇస్తారు అందుకే మీకు నార్త్లో చూడండి వింటర్ వెకేషన్ ఎక్కువ ఎందువల్ల ఆడు ఉండలేదు సరే -0 -2 -4 ఉంటుంది. సో కూర్చోలేదు వాళ్ళకి సమ్మర్లో ఎండగా ఉన్న సరే చెమట పడదు. మనకి ఇమ్యూనిటీ వల్ల లాట్ ఆఫ్ స్వెట్. యువర్ స్వెట్టింగ్ యూ గెట్ ఎగ్జాస్ట్. అది described syllabus that is lawful. What is lawful, what is not lawful is specified in section 23. Once again, you find a similarity between free consent and lawful. Any person who gives consent is normally presumed to have given consent freely. Similarly, when two parties enter into an agreement, they will be deemed to have entered into an agreement with the lawful object. So when there is no free consent, is answered in Indian contract. On same lines, when the object is not lawful, is answered because when the object is lawful, impossible to answer. When you can say that the object is not lawful, is specified in section 23. It identifies 5 important clauses. Number 1, when it is contrary to law, common sense law, 2 persons entering into an agreement for killing a third fellow, 1 person killing, other person giving consideration. Definitely its object is to do something that is forbidden by Indian law. So it is unlawful. Similarly, for example, there is prohibition. During prohibition time, there is an agreement between two people for importing liquor. It is also prohibited law. First important. I don't think it requires more explanation. What is it? If permitted, it would defeat the provisions of law. On the face of it, nothing wrong in it. It appears to be perfectly okay. But there is a sinister motive behind it. There is a reason behind entering into the agreement. If you enforce the agreement, it would defeat law. Give a simple example. I have borrowed money. I have not paid. People filed a case against me. They obtained a decree. To execute the decree, they have put my property for auction. When my property is being auctioned, can I participate in the auction? Because if I am permitted to participate, it means I am in a position to pay money. Normal rule is, if a 20 lakhs worth of property is auctioned by court, it will go for 2 to 3 lakhs. Loan is 15 lakhs. Property is worth 3 lakhs. 20 lakhs. In the bid for 3 lakhs, I can get back the property. So I entered into an agreement with a friend. I won't participate in the auction because it is my property. You participate in the auction. You purchase it. I give money to you. Keep it in your name. After some time, you transfer it to me. This is the agreement. For going through this process, I am going to give you 2 lakhs. In other words, instead of paying 15 lakhs, I am just getting the property back. Entire debt wiped off by simply spending 5 lakhs. Moreover, the person who is actually participating in the auction, is he participating on his behalf or on my behalf? On my behalf. It is as good as he bidding on my behalf. Instead of myself physically participating, I am asking him to participate. What I am prevented from doing, I am getting it done to him. If that is permitted, if he is allowed to participate and get the property, and afterwards I can take the property from him, I can go to a court of law and compel him to give the property to me by taking 2 lakhs rupees. Then what I am prohibited openly, I am doing it indirectly. When I can't enter into something from the main gate, I am now trying to enter into the same thing from the rear gate. So friends, it would defeat the very provision of law. What is the provision of law? The person whose property is being auctioned cannot participate in the auction. That is the provision of law. We are circumventing it. We are overcoming this restriction by a device. If this device is permitted given legal recognition, the very rule becomes nullity. It gets totally defeated. So, second important doubt is, if permitted, if it is likely to defeat the provisions of law, then it is not having law. Third, if the object is to cause injury to body or harm to body or injury to damage to property. The very object of the agreement is kidnapping a person. Agreement between 2 people to kidnap a person. Agreement between 2 people to damage property. Don't think that these 5 clauses are exclusive compartments. They can be overlapping. Contrary to law, causing damage to person and property, both virtually cover similar area. So each one is not an exclusive ground. You can bring the same example on the ground 1 as well as ground 3. First one is contrary to law. Second one defeats law. Third one causing injury to property or person. 4. Opposed to public policy. Unfortunately, what is public policy nobody can say. But there are certain basic policies which every polity or state will continue, society will adopt. whatever that is entered into should not be against that policy. Because if it is against that policy, then the state will not be able to survive as a unit. Hence, public policy is an accepted ground in every legal system, but unfortunately, nobody can lay out the grounds of public policy. As and when a case comes, if the court cannot declare it illegal under any other ground, it may bring it under public policy. Therefore, a caution was given. Public policy is like an unruly horse. You may get astride and thrown off. So be careful. It is a warning given to the jail. Whenever you are trying to bring a case under the public policy and declare it illegal, be careful. You are riding on a unruly horse. Be very careful. Only in extreme cases you invoke the ground of public policy. Last ground, immorality and unethical. Well, what is moral, what is immoral? It's again the standards of society determine it, the living conditions determine it. Whatever is immoral yesterday need not be moral today. Whatever is moral today may become immoral tomorrow. So, but whatever is normally considered immoral, playing cards, is it considered moral?
No.
Giving a daughter in concubinage, is it considered as moral? So please, there are certain laws of the society, certain values in the society. If any agreement is likely to defeat those values or those social norms, then it is considered to be opposed to ethics and morality. 5 grounds: contrary to law, defeats law, injurious to person and property, public policy, morality and ethics. If the object of the agreement is to be attracted by any one of these 5, if it is contrary to law, if it is likely to defeat the law, if it is likely, if the object is to cause harm to property or person, if it is opposed to public policy, and lastly, if it is immoral or unethical, then courts will have no hesitation to declare that the contract is illegal because the object is not law. So go back to section 10. All agreements or contracts, if they are made by the free consent of the parties competent to contract for a lawful consideration with a lawful object and are hereby not expressly declared to be void. There are certain agreements which are declared to be void under the Indian Contract Act. Most of the textbook writers combine both of them. They start from section 23 and end with section 30 as part of this lawful object chapter. Let me bring those sections also to your notice. We start with section 26. 26 simply declared that any agreement in restraint of marriage is void. Well, should a person be given the liberty of hanging himself? Committing suicide? Yes, sir. Should he have the right to commit suicide? So he must also have the right to marry. Because marriage is also one kind of suicide, here the freedom is lost. That's what one great person has said. Boys, not they get empowerment by marriage. We get losing power by marriage. Anyway, if an agreement is there between two people, whereby one person agrees, I will not get married in the next 30 years. Suppose he changes his mind after 2 or 3 years and wants to marry somebody. Can he be restrained? Friends, our constitution values certain fundamental rights. One such fundamental right is to do whatever I wish. And most important fundamental right is to have company. People, human being, always needs somebody's company. How can that company be denied? Therefore, if the object of an agreement is to deny a person to have company, then that agreement is void. It is specifically declared in section 26. Any agreement in restraint of marriage is void. Go to section 27. Normally, section 27 is the criteria for questioning. Section 27. Agreement in restraint of trade void. As a citizen, right to carry on any profession, trade, business or employment. Can that be surrendered by means of an agreement? They are called fundamental rights. How can fundamental right to live be surrendered, and many people in order to live has to accept employment or has to accept carry on some trade? We take up employment. I get employment and I agree to serve them for 3 years. And if I quit within the 3 years, I am going to pay you some few lakhs of rupees. I get a better opportunity. Can I give up? Employer says, no, you can't give because you have agreed to serve for 3 years. If you want to leave before the expiry of 3 years, you have to pay us this money. Should I give? English law lays down one important restriction. It says, an agreement in restraint of trade is void unless it is reasonable. That means English law permits a reasonable restraint, whereas Indian law virtually doesn't make any distinction between reasonable restraint or excessive restraint. In fact, Section 27 doesn't impose a duty upon the court to make an inquiry whether the restraint is reasonable or otherwise. Any sort of restraint, any restraint is void according to Indian law. But take an example. A person joins an industry. The industry owner sends him for some special training to a foreign country. Entire expense was met by him. The fellow comes back and joins. He was made to sign an agreement because you got special training. I want to have the benefit out of it. You please serve for minimum 3 years. If you don't serve at least for 3 years and then you want to leave, you have to pay me some money. Can he leave? Because here you have employer's interest, you have employee's interest. How to maintain that interest? How to maintain balance in the business? Unfortunately, Section 27 of Indian Contract Act does not envisage such a situation at all. It is totally absent of this. It doesn't speak anything about it. But fortunately, the Indian judiciary, taking lead from the English decisions, have also started inquiring whether the restraint imposed by means of an agreement is reasonable. So virtually English concept of reasonable restraint has been imported into India. Here also we are seeing whose interest must be protected. His interest to accept any employment, his interest to maintain continuity and simplicity. Take for example Coca-Cola. There is an essence. Essence formula is not known to everybody. It is known only to few individuals. Suppose a person wants to leave that factory. I am sure any sane employer will say you should not divulge this information to anybody by becoming a partner somewhere or by accepting employment elsewhere. Otherwise, who will purchase? The secret will be known to others. So he may put a restraint. Such a restraint is definitely valid because employer's interest must be protected. So you have to balance the interest of the employer and employee, and the best way to balance is by asking the simple question whether the restraint is reasonable or not. So virtually, even though it is not stated in the Section 27, it is virtually an accepted principle that is restraint which is reasonable is permitted even under Indian law. So the word restraint as applicable in Section 27 means unreasonable restraint. It is not a reasonable restraint. Then go to Section 28. Section 28 speaks about access to law. Do you have a right to go to court? Yes. Can you be denied from going to court?
No.
Two parties enter into an agreement. Any dispute arising out of it, it should not be settled in a court of law. One party wants to go to court for settlement of the dispute. Can he be denied?
No.
Fundamental right to carry on trade, fundamental right to speak, to move. There is also a fundamental right to approach judiciary. So it cannot be done. Similarly, there is a period of limitation. Promissory note, you can file a case When law says 3 years time is permissible, period of limitation is there. Can it be extended to 4 years? You cannot deny access to the court, either from going to the court or as far as the time limit within which a person has to do. Any agreement in restraint of legal proceedings is void according to section 20. But please remember two exceptions. First important exception is to go into arbitration. Suppose two parties make a point in the agreement, a clause in the agreement, that if any dispute arises, it must not be taken to a court of law, it must be referred to arbitration. It is definitely perfectly valid. That is the first exception. Second important exception is, suppose the parties agree that the dispute must be referred to a particular court only. Most of the times when you purchase items, it will be written on the top, subject to Bangalore jurisdiction, Calcutta jurisdiction. That means you want to file a case, you have to file a case there only in the Calcutta or Bangalore. That is not taking away the jurisdiction. It is not in restraint of legal proceedings. It is perfectly valid according to law. So dealing with law and approaching courts, only two exceptions are there. Number one, agreement to refer the dispute to arbitration. Number two, agreement to refer the dispute or the access to the dispute to only one party. Except in dispute, any other type of restraint, either from the time perspective or from the form, that is the court perspective, is definitely void under section 28. Go to section 29, which already I have covered to you when dealing with offer. I told offer signify means not only communication, it must also have terms which are certain or at least capable of being made certain. What is the example here? I agree to subsidy you 10 liters of oil. Which oil? Uncertain. But suppose the parties only deal with the fellow only deals with coconut oil and you went and purchased it from him on several occasions. Then when you say oil, it means only coconut oil. Though it is not clear, it is capable of making clear. That principle is contained in section 49. Agreement is void for uncertainty. If the agreement doesn't contain clear meaning, it is void. 29 uncertainty, 28 legal proceedings, 26 trade, 27 trade, 26 marriage, 25 consummation. Okay. Now go to last section, that is section 30, which is wager. Wager means betting. Should we permit betting?
No.
Calcutta Knight Riders win or other thing? Punjab 11 wins. Betting is taking place, but that is not permitted. Races. People investing a lot of money, suited, booted, tied, hatted, will be shouting at the pitch of top of their voice, "Come Rani, come!" Rani is the name of the horse. Is it permissible? It is permissible because of money the government gets. Otherwise, it is also better. It is not depending upon the skill, it is depending upon the luck. Any game which depends upon the luck is called betting or wager. కోడిపెట్టలు పందాలు అవుతుంటాయి, ఉరుకులు పందాలు అవుతుంటాయి, పండగ అవన్నీ కూడా why all that? Even playing cards, that also depends on that. All of them are valid. Only two are declared deliberately valid because it is a money making process for the government. One is lotteries, second is races. Except in this two, any other type of agreement which calls for luck, which outcome of which is dependent on luck, not on skill, is considered to be a wager agreement, and all agreements by way of wager are void according to section. Okay. Any questions?
Sir, sometimes they were giving bits that wagering agreement is an analysis options వచ్చేసరికి opposite to public policy and some other options. So wagering agreement, obviously it is opposite to public policy. And again another bit, wagering contracts they were mentioning like that, sir. How is it possible? How the wager will become into a contract?
Normally, the heading of the section is agreement by way of wager is
Wager
void.
is what?
If it is a wager, it is not a contract. It is an agreement which will never transform into a contract. Therefore, wager contract is not appropriate way of using.
Yes.
See, unfortunately, Indian Contract Act, certain expressions are used which are meaningless. Valid contract, we say. What do you mean valid contract? What is contract?
That itself is valid, enforceable by law.
Valid contract. Valid agreement enforceable by law. Agreement enforceable by law means it is enforceable. What is the one of saying again? Valid agreement enforceable by law.
Yes.
Similarly, what is void? Invalid.
Invalid.
What is contract? Agreement enforceable
Enforceable by law.
Can there be invalid agreement enforceable by law? Popular use is void contract, valid contract.
Valid.
Actual use is contract void. Not even void contract, void agreement.
Agreement.
Normally we use the expression void contract when it becomes void later, not at the time of entering into contract. Take for example frustration. At the time of entering into contract it is there, perfectly valid, validly formed. But afterwards the contract becomes void because of happening of something which is beyond the control of the parties. So void agreement, void contract. Unfortunately, we use both of them interchangeably. Same is the case with contract and valid contract. Whenever we say valid contract, we mean contract. Whenever we say contract, we mean a valid agreement enforceable. How can there be valid agreement enforceable by law? Can there be invalid agreement enforceable by law? So, popular usage is different from the actual linguistic, legal meaning of a phrase. Best use is void agreement. Contract. Opposite of contract is void agreement. Because contract is a valid agreement. That is the best way.
Wager contract మళ్ళీ it is not opposite to public policy అనేసి మెన్షన్ చేస్తున్నారు సార్.
I can often
How that is.
I can often say.
Check once.
Objective type question answer చేసేటప్పుడు ఫస్ట్ మీరు ఎలిమినేషన్ ప్రాసెస్ కి వెళ్ళాలి. సెలెక్టివ్ ప్రాసెస్ కి వెళ్ళకూడదు. ఎలిమినేషన్ ప్రాసెస్ వెళ్ళిపోతే narrow down ఉంటుంది సెలెక్షన్. అప్పుడు you have to apply your logic and then see which is the best answer out of the available two options. ముందు నుంచే మీరు ఇంక్లూజివ్ పాలసీలో వెళ్తే దాని ప్రతిదీ ఇంక్లూజివ్ గానే కనిపిస్తుంది. ఎక్స్క్లూజివ్ పాలసీతో అప్రోచ్ కావాలి. That is the difference between answering an objective question vis-a-vis a subjective question. ముందు ఏది కాదు, ఖచ్చితం ఇది కాదు తీసేయండి. నెక్స్ట్ స్టార్ట్ చేయండి. నార్మల్గా ఇట్ బాయిల్స్ డౌన్ టు ఓన్లీ వన్. అంటే బేసిక్ కాన్సెప్ట్ క్లారిటీ ఎప్పుడైతే ఉంటుందో, however twist he may put in the options, you will definitely be able to follow the patterns. That's all. Major agreement is section 29, 30, ఇవన్నీ కూడా but starting from section 25. The word used is agreement. Agreement without consideration is void. Agreement in restraint of marriage is void. Agreement in restraint of trade is void. Agreement in restraint of legal proceeding is void. Agreement, the meaning of which is uncertain, is void. Agreement by way of wager is void. There is no word of contract. Because if there is a contract, there is a question of void. So very clearly, very cleverly, the framers used the expression agreement, not contract. Don't use. But suppose he uses wager agreement and wager contract. Then wager agreement is void is a correct answer. Not wager contract. There can never be a wager contract. Wager contract means maybe in this way it can be used. The exceptions, lottery, horse races. There is undoubtedly a contract because it is enforced under the court of law, even though it involves the nature of betting. Because it is based upon luck, not on skill. We say it is a wager. Yet because it is recognized and enforceable by law, we call it a contract. So that is how we can distinguish. Exceptions come under wager contract. the agreements we follow to the rule or the wagering. That's how we can check. Which class is next class?
Resorts.
I will be leaving now. I'll be back again on evening.
Okay.
If you have any doubts, you can come and ask me. Internet is as well. I've been Dr. Alvia's
Sure.
18th to 23rd, 5 days I am available here. You can come and ask me any doubt. The email will go through it. Whenever you get it out, please come and ask me if you have any objective questions which you find because of the what you call language that you use, you are unable to decide is it this one or that one. Bring it to plan.
Sure.
Feel free to come and contact me anytime. We'll take you and 24th onwards I will not be available because I have to join university where I am actually going. Okay?
Sir, another small thing. Sir, A and B entered into a contract, sir. A is a rice dealer, sir, and B is just a buyer. What their agreement was, B is intending to purchase 100 bags of rice, but if the market price comes to 100, for example, then only I am going to purchase those 100 bags.
Conditional contract.
Conditional contracts.
Agreement.
Agreement. If the price goes beyond 100, I won't purchase the rice bags. So
Right.
that was the
Agreement between
agreement between them. So later on, the price was like huge, sir,
Okay.
for some time, and for some time it was like below 100 actually.
Okay.
When the price was above 100, he said that I am not intending to purchase those rice bags. Can this contract be made it as valid, or else?
See here, when two parties agree that I will purchase depending upon the price variation.
Yes,
What is
fluctuation.
the date that is specified in the contract? Or what is the tenure that is specified in the contract? What is the period that is mentioned in the contract?
Within
Is it within 1 month? Is it on a specified date? Is it within 1 year? Suppose it is in 1 month. First 1 week the prices went up. Next 1 week prices came down.
Came down.
First 1 week he cannot be compelled to purchase. Next 1 week he can be compelled.
Compelled.
If he doesn't purchase, he will come to reach. And when it is less than 100, the other fellow doesn't sell, he will come to reach. But suppose it's on a particular day. On that day it is more than 100. He is not bound to purchase. Next day it may come down. Contract has no existence at all because the contract is over what the day is over. So unless you read the terms of that particular agreement, you will not be able to answer.
Okay. If it is for 1 month, sir, the first 15 days it was like below 100 only, but later on it went on to somewhat of like
Fine.
200.
The first 15 days he must purchase.
He must purchase, but he hadn't do so.
The seller has to ask him to purchase because it is
If he
less
was
than 100.
silent, sir, then
He is silent, then he is not interested in selling it. It all depends upon the wording.
okay.
Whether seller has to give a notice, whether buyer has to purchase on his own, whether prior intimation has to be given by the seller to the buyer. All this depends upon the agreement. Unless you go through all the terms and conditions laid down in the agreement, you will not be able to answer. Because here the question is not formation. Here the question is performance.
Performance.
Performance depends upon what are the conditions agreed in the contract.